Hello and welcome. Thank you for joining us for our third webinar in our series, The Hardware Marathon. We're taking a look at the different phases involved with developing some hardware products, as well as some of the obstacles encountered along the journey. My name is Jenny Loper, and I will be your host today. And I'm also joined with Laura Schneider. If you missed our last episodes, we were looking at ways that we can utilize iterations to our advantage, and the importance of using communicate your vision of the product to others. If you are able to catch those, feel free to see them on our YouTube channel. In our webinar today, we're going to take a brief look at how to protect your idea and the intellectual property that is developed. We will not have time to dig in very deep into this topic and get a high-level overview, and you're certainly welcome to follow up with us after the session if we weren't able to address your questions. Of all the phases in hardware development, this may be one of the most expected steps in the marathon, but it's also subject to a lot of myths about what's involved. Hopefully in our conversation today, we'll be able to dispel some of those myths. As I mentioned, my name is Jenny Loper. I'm the Director of Operations at Zebulon Solutions. I've been in manufacturing since the age of 6, working in my father's machine shop. And after completing my degree in physics, I've held various positions in every aspect of developing a product, from research, testing, and even scaling production to over 40,000 units per month. While most of my career has been spent working after the product has been designed, and I have over 2 decades of experience in manufacturing, quality, supply chain management experience. In my current role, I have a lot of conversations being their first product, which was really the basis for creating this webinar series. As I mentioned, I'm joined by Laura Schneider today, and some of the milestones in her career that has guided her path into being a patent attorney include: in 1998, she earned her Bachelor of Science degree in mechanical engineering from Texas A&M University College Station, and began her career as a mechanical engineer. In 2004, Laura embarked on her intellectual property journey in Munich, Germany, before becoming a U.S. patent agent in 2010 and a licensed attorney in 2014. She founded her law firm in 2018, where she continues to practice today. Laura, thank you for joining me. I'm looking forward to learning more about how to protect ideas.
Thanks so much, and thank you for having me. I look forward to it.
Yeah, in our discussion today, I'm hoping we're going to cover some of these topics about getting just a high-level overview of the ways that intellectual property can be protected, and some differences between domestic and international IP protection. And then at the very end, kind of like, how does someone get started down this path? To our audience members, thank you for joining us. We would love for you to engage with us during this event. If you have any comments, feel free to post them in the LinkedIn Live window. Questions there that will pop up on the screen, and we'll be able to see them. We will try and answer questions throughout the session today and take a brief pause between sections. Excuse me. So I think with that, let's go ahead and get started with our high-level overview of the different ways intellectual property can be protected in the US. Laura, would you mind giving us a brief overview of the various ways to protect intellectual property?
Yes. So intellectual property, just like the name implies, really it applies to protection of creations of the mind. So you've got 4 main types of intellectual property. You've got patents, which give you the right to prevent others from making, using, or selling your invention. Followed by that, you've got trademarks. Trademarks are more like they're really intended to protect the consumer. They actually originated back in the old baking days in England, when people needed to know they were buying the original bread from a certain baker around the street. And so they would stamp the bread actually with the mark, and then it grew to blacksmithing and so forth. So consumers need to know they're buying an original Coca-Cola product or an original Ferrari and not a knockoff. The next type of intellectual property would be copyright. That protects you from others actually copying your work. So if they independently come up with the same Monet or something like that, you know, you know, that's too bad for you, but it's not copyright infringement, right? But it prevents people from creating and selling knockoffs of your product. And then finally, one of the more neglected aspects of intellectual property is trade secrets. Trade secrets are literally secrets. You need to protect them. Don't let those be disclosed to the wrong people. And as long as it's a secret, you can keep it in perpetuity. Most famous trade secret is the Coke recipe, right?
I've heard that one as being like the most
Yeah,
famous
yeah,
example. Yeah.
yeah.
Which of these are you the most familiar with?
Um, I would say patents, trademarks, and copyrights are all pretty equally in my space and what I deal with on a regular basis, just because it helps to have an attorney involved to register those. Whereas with a trade secret, that's a little bit different. That's, you know, don't, don't post it on your website, that kind of thing. So the trade secrets, I just mention those to clients to make sure they don't forget about them.
That's great. Okay. How can you talk a little bit about what types of intellectual property each of these best protects? So,
Right,
what does a patent best protect, and so on?
right. Um, That's a good one. So patents best protect things that take a long time to develop and have a lot of, uh, high cost of entry. Think like developing a new medical device or something like that. So once you've developed that, you really want a monopoly on the ability to manufacture that medical device so that you recapture all of the money you've spent developing it. A close second, or in conjunction with that, would be trademarks, simply because your brand is so important. And we see that today consumers, it's all about the Stanley Cup, right? Where, my husband the other day was very upset about his Yeti cup, the lid finally breaking. I'm like, that is so 1990s, right? Um, you know, they're the same as far as I could tell. So they go hand in hand, the patents and trademarks, but they do serve different purposes. Mm.
Okay. What about copyrights? What do they protect?
Copyrights are kind of fun. They overlap a lot with trademarks because, say somebody, and especially when dealing with Amazon ripoffs and things like that,
Mm,
we do a lot of takedowns um, of Amazon postings for cheap knockoffs. So they will, copy the trademark. Well, that's directly copyright infringement. So
mm,
you don't have to have a registered copyright in place in order to, enforce your copyrights. Um, However, you do have to have a registration in place, subject to a whole bunch of, constraints if you want to be entitled to statutory damages. But most of the time, the trademark holder simply wants the knockoffs gone. You know,
right. Right. Yeah,
yeah,
get them out of the space.
yeah, yeah.
Okay. Um, are there any? What would you say are like the pros or the cons associated with each? Are there?
Yeah, pros and cons with each. So patents. Um, the pros are, you know, once you have a patent that issues, is that it really is a monopoly. Um, you can buy or sell or license rights to a patent, just like you can buy or sell license rights to real estate, right? So it can be a valuable asset to your portfolio, especially if you're a business that might be selling.
Mhm.
Um, the biggest two cons to patents are, One, the expense. They are not cheap to prosecute, um, not cheap at all. And so it's really hard for startup businesses to get in the door with patents. And so they're constantly, balancing and, making this calculation. Do I pay for my patent or do I pay for product development this month?
Mhm.
You know, you're constantly trying to walk that line. Um, that's the expense. The second biggest con of patents is that a potential infringer, you know, infringers are very smart people too. We have to give them credit. So if they have in their product every single feature that is in your patent claim, except one, they have not infringed.
Oh.
So, what makes it very difficult in that regard is that, talking about startups, they are dealing with very tight budgets. So, they don't have the resources to pay an attorney to spend a lot of time thinking of every possible reframing of a word to head off a competitor. But then 15 years down the road, they're dealing with infringement, and they thought, well, we could have avoided that problem using a different word 15 years ago when we had $1,000 budget. That's hard. That's hard.
That's a real challenge to
Yeah.
not have the foresight
Yeah.
and then also the money to take care of it. Absolutely.
Yeah. Yeah. So that's the pros and cons of patents. Pros and cons of trademarks. Um, One of the pros of trademarks is that they are not too expensive to prosecute. Um, and as long as you are using the trademark in a way that will be seen by the public as a trademark, you can maintain your trademark in perpetuity. So they don't have an expiration date. I guess that should be another con for a patent, is that the patents have an expiration date, 20 years or 15 years if it's a design patent. So, you know, not necessarily have a trademark expiration date. The cons of trademarks is that, they are a use it or lose it kind of deal. So if you have something like a product line on a particular that's, running under a particular trademark, then, you have a potential of actually losing the rights to that trademark, use it or lose it. And the presumptive, the presumption is that if you don't use your trademark for 3 years, you have abandonment. I mean, there are all kinds of, everything that I say has a qualifier. Just
Sure.
want to say that for everybody. But, it's, there's the possibility of losing it after 3 years.
Gotcha. Knowing that when you need to take advantage of something is important, and also knowing what your limitations are. I think
Right.
that's and going into this for the first time, you wouldn't have that insight. So
Right.
good to
Right.
talk about that. Yeah.
The pros of copyright are really virtually zero expense if you want to register those. I think the current fee with the Copyright Office is $75 to register your copyright. However, when it comes time to enforcement, there are two cons with that. One of those is that you have to prove that the other party actually copied your work. If they independently created the same work, doesn't matter. Now, most of the time you can prove it simply because, I mean, if they publish a novel and 70,000 words of the 80,000 word novel are the same, well, they probably copied it, so it's kind of a no-brainer there. One other con with copyrights is the timing of registration. So, you're not entitled to statutory damages unless you have registered your copyright really shortly after your filing, within a couple of months, or if you register it before the other party has copied your work. So if you don't do that, and somebody else copies your work, and then you go seek to, file your copyright application, um, you can be out of luck there because for statutory damages, it could be late. And then you've got to prove a loss of actual work. So the burden drops to you to prove damages. With trade secrets, you know, the big advantage of a trade secret is that you can keep it in perpetuity if it remains a secret forever. However, once the secret is out, it's out. You
Yeah.
know, um, that's a huge con. And you know, uh, yes, again, there are always caveats around that. If it was a disgruntled ex-employee who released the secret and so on, you can, run after that person for damages, but you can't squeeze blood from a turnip. So, would and they're unemployed.
Right.
So, you may or may not have any recourse there. So that type of thing. So there is a big potential downside to trade secrets, but you never know if it's something that you can safely keep a secret. I think the KFC recipe is also still a secret. I think what they do, they keep all of the employees, they have different, just part of the recipe. Um, you know, so it's
So if they ever get together, it might get out. But
right, right. You know,
there you go. That's good. Well, thanks for running through that. I'm going to wrap this section
sure.
up right now and see audience before we get into our next division. But
Okay.
that was a really good overview. I thank you for taking time to talk through all of those and
Sure.
see what the differences are. I think in hardware development, while I'm waiting for a question to come in, I think in hardware development, and I think it was great how you brought that all of those. I think previously I've heard that like copyright tends to be less in hardware, but I appreciate how you did bring that forward.
Hmm.
So,
Yeah.
let's see, what is
So
our
the
question here? Yeah.
yeah, yeah. The first question here is if I have a patent on my product, do I need to use non-disclosure agreements with my vendors? I still would recommend that simply because when you are talking to your vendors, the things that you are sharing with them um, involve more than just what's in the patent. You know, you are potentially talking to them about, um, things that are secrets like your customer base or your volume of sales, things like that, or maybe who your other suppliers are, maybe because maybe your vendors need to coordinate across multiple vendors. So those are all things that are still secrets, and those are trade secrets. Who
Right.
you source from is a trade secret generally. So short answer is yes. Keep using the NDAs.
Yeah, that was a good question. I think I think that trying to find the easy way out because NDAs can be sometimes cumbersome. So I think
Yeah, cut them
that's a
down to
great
two
idea.
pages. It's fine.
Right, make them easy. Exactly. All right.
Yes, you don't need the lawyers making it hard for you. Trying to think about every possible scenario,
Okay.
just fall back onto the common law interpretation of everything.
That's good advice. Yeah, we should have our next session, but I'm sure we could have a whole
Okay,
session talking about just NDAs alone because there's a lot in those.
sure.
Well, let's get into domestic versus international intellectual property protection. I'm curious from your profile, what led you to intellectual property protection in Germany?
Oh, that's easy. I lived there at the time. So it wasn't some, calculated, uh, effort on my part. I lived in Germany and I really did not enjoy being an engineer. I would love, um, I wish I was like the engineers who I worked at BMW
Hmm.
in Munich, Germany. Every mechanical engineer would kill for
Right.
that job, and I hated it.
Really, it's interesting.
Nothing against BMW, I just didn't enjoy it.
Just personally,
Yeah,
intellectual
yeah,
property law was more interesting. And we're
yes,
all made different. That's great.
Yeah.
All right. Well, could you talk a little bit about what the limits are of domestic patents in the global marketplace?
Yes. Um, they're domestic patents. A United States patent is only enforceable in the United States. Um, that's that's the end of the discussion. So if you want to be able to enforce your patent outside the U.S., you're going to have to secure a patent in that country of interest. There is no such thing as an international patent. There are, we could file a placeholder that will kick the can down the road a year, 18 months, just so that, to buy you a little bit of time to, validate your product, establish relationships. But ultimately, you're going to have to prosecute a patent in each country of interest.
Wow.
And don't rely on NDAs for China. They will sign those. They will sign them all day long, but they are not enforceable there. You have
That's
to get a Chinese attorney to write the
mm,
NDA there.
that's a good point to make. Thank you. Um, so, national patent. How do you determine which countries? I mean, in the with the internet, I mean, basically the entire globe could be a
Mhm.
marketplace, and so, how do you determine where do you want to try and file patents and protect your ideas?
Right. So typically, you're only going to file your patent applications in the countries where there's either going to be high rates of shipping through that country or um, being sold directly in that country or manufactured in that country. So, really, the top countries where we file would be Germany. There's just especially for things like medical device products. That's where everything's in Germany.
Hmm.
You will a lot of people manufacture in China. It's going to possibly ship through Japan or South Korea or Taiwan. That's also fairly common.
Okay. All right. So really, where you're doing the bulk of your business, either on
Mhm.
the sales
Yeah,
side or on the purchasing side.
yeah. Sell side or supply
Mhm.
side. That's what you base the decision on.
Okay. What differences do you see in enforcement? And this is probably a very big question, but between like domestic, how things are enforced domestically versus other countries, and how that enforcement works out.
Oh boy.
I
So,
know we don't have
um,
like 5 hours. I know, but
yeah. So, enforcement in the United States, it's always, it's a high dollar litigation very quickly. And the sad thing about that in terms of patents is the one with more money wins. The
mm,
one who can last through a $1 to $3 million lawsuit is going to make it. Samsung and Apple, they're in litigation over the same two patents for 10 years. That's a lot of money.
yeah.
Um, that's how it's done in the US. And internationally in Europe, the lawsuits tend to be slightly shorter, slightly less expensive. But on the flip side, um, they generally don't get awarded damages like we get in the U.S. And by damages, what I mean is that the winning party would be, who enforced the patent, say, will be awarded a reasonable royalty, pretty much equivalent to what he would have gotten if the other party would have licensed to begin with. So there's not so much of a deterrent.
Yeah.
They don't have the trouble damages route like we do
Mhm.
here. So there's not as much of a deterrent. But they do respect the patents, and typically the parties there will respect patent claims a little more quickly because they know it can happen to them too.
Mhm.
You know,
Mhm.
um, China, they're trying to change that with the courts. They are in the early stages um, with setting up more enforcement procedures for enforcing patents there, but they are still a few years behind on that. But I am hearing reports of more, um, more patent holders having success enforcing there.
Yeah, well, I'm glad to hear that. I mean, I think that that's been one of the big concerns about doing international is, how can you protect that, protect your ideas? So, we're running a little behind on time, but I will stop for one quick question if we have anything to talk about on the international or domestic enforcement. I mean, I think that one thing that's interesting to consider is that, it costs money to get the patents and whatever internationally, but then also understand that your enforcement of those might be more costly. So let's see, what's our
Yeah.
question here? Um,
So, if my patent was infringed upon in China, can I seek damages for lost revenue? Um, I'm pretty sure you can. I'm pretty sure, but uh, I would have to ask my. I have associates in China. I would have to ask to be sure.
okay. Yeah, the person, if you
Yeah.
want, feel free to send a note to us through the Zebulon website,
Mhm.
um, if you would like to get in contact with Laura, and we can get that followed up on later. We need
Yeah.
to do that. So let's go on to our
Yeah.
last section here, which is really about how to get started with protecting your idea. Um, when would you say is appropriate to start protecting your intellectual property?
Right. So, the sooner the better. You want to uh, make sure you have at the early stages, you know, the first thing you would start with is your NDAs. Make sure you've got an NDA in place that's protecting your secrets before you have an invention. That's your business idea,
Mhm.
so that you can start talking to people. um, Shortly after that, you'd like to ideally start talking to an intellectual property attorney about both patents and trademarks because they complement each other. Sometimes that drives, um, some changes in your product design. So you want to make that hand in hand. But on the other hand, you don't want to, throw so much money just getting a patent to get a patent when you don't have a product either. So you've
Mm,
got to find that balance. Um, yeah, the investors. A lot of people are contact me. They want to get a patent to issue and then they're going to sell it. Well, that's nice in concept, but investors typically aren't going to jump in until they've seen the concept proven. So they want to see that there's a market for it. They want to see your initial sales and things like that. So it is a long haul kind of deal.
It's interesting you bring that up. I think that we'll probably touch on that more in our next
Mm.
webinar.
Yeah.
But that's because there's a lot of people that come to us and say they want to just develop it enough to sell the idea. And I think that
Yeah.
people do underestimate effort of development that's necessary in order to actually be able to license that idea.
Yes. Yes.
Okay. What are there? I know that when people are we're dealing with startups, and money is scarce, and so a lot of people want to file their own provisional patents. Are there some
Mhm.
benefits or drawbacks that people should be aware about if they want to go down that path?
Yeah. So provisional applications are only applicable in the United States. So if you have
Mm,
any notion of expanding internationally, um, you need to talk to an attorney and really reconsider that decision if you have the money. Now, sometimes if you really just don't have the money at all, a provisional application, it can be a placeholder at least to get your foot in the door while you're proving your concept. But you do have to keep in mind that provisionals are just they're um, they're not a basis internationally.
that's good to know. I actually didn't realize that the provisionals
Mhm.
were only good domestically. So
Yeah, yeah.
Thanks for bringing that up. You're unique in the fact that you've held both patent agent and patent attorney roles. Can you provide some information, some insight as to how those two functions work together, what they and how they're, what the benefit is at working with either one of them?
Mhm. So working with a patent agent for sure is going to be less expensive. They're um, we'll say they're not paying off law school student loans or something like that.
Right.
But they're certainly they have to be engineers, so and they have passed the patent bar. So they're certainly qualified for filing and prosecuting patents in the United States. Where it gets problematic is um, a a lot of the advice that you will turn to a patent attorney for is going to be a lot of crossover advice, and so your patent agent is not so you know should not be advising you on legal matters outside of prosecuting the patent application. So if you have a trademark issue, that's
Mhm.
that's a no-go. Also, patent agents aren't trained on the international aspects, so the claims might not be written with an international case in mind. Again, I don't want to say you should never work with a patent agent. Just understand that um, those are the considerations to keep in mind. But again, when you're an early startup, um, you're going to do whatever you can to have some protection in place, whatever that might be. Yeah.
So it might be better to hire an agent than trying to go it alone.
I definitely would do that. I mean, you don't want to go it alone. There's so many, with prosecuting a patent application, there's just so many nuances to interpreting an office action. And, I see that. I see people who try to prosecute their own patent applications and they get rejected and rejected, and then it's abandoned, and they don't know why. When really, what I see is a 15-minute issue that we can take care of. It's not a problem. They're just missing the issue that is pointing out.
Gotcha.
And a patent agent would catch that.
Gotcha. Okay. Yeah, it's definitely, you don't know what you can protect yourself from if you've never been down the path
Yes.
before. So, yes, we one of the mantras we have at Zebulon is to work with the experts and hire the experts in the field, and to utilize their experience as opposed to trying to do everything on your own, because
Yeah.
you can't be an expert in everything. So,
Right.
yeah.
Right.
So once ever, let's kind of wrap up today with, I guess, after someone has an idea, they've proven it out, they've had their NDAs going or what have you. What is the first step that needs to be completed to really begin protecting that idea in the marketplace?
Mhm. Well, the first step is the NDA.
Mhm.
That's an important first step that they've already taken. If they are on a shoestring budget, I would recommend that they don't forget about trademarks. A lot of people are, thinking about patents and, they worry about that. And I wouldn't say ignore those, but keep in mind that trademarks can be an important tool that are not so expensive in the early days.
All right. Yeah, that's an important point, because I will tell you, I only think about the patent piece. So thank you for bringing up the trademark piece.
Mhm,
That
mhm,
that does get out of my brain when I'm thinking about this in general. Just
mhm.
we don't do anything with either one of them really, and so it's
Right.
all outside of my wheelhouse.
Mhm.
All right. Well, I think we're at our time today. Are there any questions related to how to get started in this early process on approaching patents or trademarks and copyrights and really protecting your ideas? Let's see.
Can a
Can a
patent be
patent?
extended beyond 20 years? Um, no, it's always, for utility patent applications, um, well, okay, Possibly. There is one small mechanism where it can be extended to 21 years, depending on
Okay.
exactly when you file the patent application relative to your international application. Um, so that's one instance, but so 21 years. Um, and I guess another exception where it might be extended is if the USPTO takes too long in examining your application. They will adjust your patent term by the number of days of their delay. So they have 3 years to examine your uh, application, but and then after 3 years, then it's on them as long as you've done everything to not cause delay. So that might extend it 1, 2, or 3 years. But again, that's not the standard. I mean, the standard is 20 years for utility, 15 for design.
Okay. All right. That was a good clarification. Just the little tiny loopholes that you might sketch a few more days or maybe a year out, right? You're not going to.
Yeah, it's very specific on the timing when you file that.
Mhm. Well, Laura, thanks so much for sharing your insights on intellectual property today and giving some little nuggets of advice that I think just not commonly known out in the conversations that I've had with people. I hope that this webinar has been insightful for our audience today as we've talked through different ways to protect how intellectual property is protected internationally and the steps need to be taken there, as well as the benefit of using a patent agent or attorney to better navigate the application process. Laura, is there one last thought that you would really, insight that you'd really want to leave our audience with today?
I would say, yeah, there's, you know, intellectual property, it can be a scary thing, navigating all of that. But, be cognizant of that. But don't don't be so fearful that it paralyzes you.
Mm-hmm.
You know, don't be so afraid to talk about your product that you don't talk about it and then, okay, you don't sell anything, or you never make that connection. So, um, maybe the advice is to be fearless. No, don't be fearless. Be careful.
Don't, don't let the fear paralyze you, but take
Yes,
action.
don't yes,
There,
yes. Be careful,
be
but
careful. All right.
don't be paralyzed.
Thank you for that. Well, we are, as I mentioned, we are at the end of our time today. Laura, thank you so much for joining me.
Thank
It's
you
been a
so
good
much,
conversation.
Jenny.
You bet.
Yes.
I've enjoyed talking through intellectual property protection in our Hardware Marathon webinar series. As I mentioned at the beginning, this is the third in our series of what will be 8. Our next webinar is we're going to start looking at how to develop a robust prototype and proving out a concept. And I hope everyone will be able to join us for that discussion. In parallel with the webinar series, we're also releasing some blogs on these topics. The blog related to intellectual property is already up on our website. If you'd like to see that, it's at zebulonsolutions.com. This video is up on our YouTube channel fairly soon. And if you have a question that you didn't get a chance to ask today or something you'd like to follow up on, feel free to just reach out to us through the Zebulon Solutions website, through the contact page, or if you want to send an email to the info, that's info at Zebulon. I'm happy to get you in contact with Laura. I think that's all we have, and we'll wrap up. So thank you again for joining us today, and hope you all have a wonderful time.
Thanks so much. Bye-bye.
Yeah.